G'day Tom, how are you?
Yeah, good Andrew, good to be back.
Yeah.
Short notice this time.
Yeah, it's the last step in poor old Nina's sick, so best of wishes for you, Nina, at home. Alright, well look, what we're going to talk about today is, we've had a major topic is going to be talking about collusion and secondary boycotting in industrial law, but we'll come to that in the end. You know, Tom, I noticed as we walked in today, there was a whole lot of parents, I was one of them, who brought a child to work, and I thought how remarkable that is now compared to 5-10 years ago. I know you weren't in the workforce then, but
Yeah.
nonetheless, it's a significant change that people would think you could bring children in public school holidays, and yet at the same time, the world's getting much tougher and people are actually releasing and terminating people's employment. And I don't think everyone completely understands that by not managing someone and then terminating, you're about to change someone's life quite dramatically. So at one level, we accommodate people, we get on with people, we do things.
Embrace the human.
Yeah, and then on the other side, we're seeing increasingly in the last 2 years, particularly as things become more volatile and tight, people aren't managing, and then all of a sudden saying, I've got to get rid of X, and not understanding when they get rid of X, that X has got a partner, children, credit card debt, mortgage, a whole lot of other stuff.
Yep.
The best businesses understand that people are their most valuable thing, but it's easy to forget, isn't it?
Yeah, I mean, it could be the worst day of their life.
Yeah.
Or, you know, they've got a whole family. It's the dehumanising of...
Yeah, and I think I guess what I'm doing, because we're going to talk about some odd cases today, but what I want to remind people, particularly leaders in business, is please don't forget that the people who work for you are your most valuable asset, and if we manage people, the likelihood of termination is dramatically reduced. But when you decide to terminate, you're not terminating a person, you're terminating a family. I just want you to think of that as a concept, and also to understand how does a person recover from it. If they have no notice of what's happening, how do they adjust, learn? The answer is, well, they probably don't. I thought I'd take you on. The Australian Institute of Company Directors has just published a paper around directors' duties, and quite a helpful document that takes through directors, what are their obligations at law. It doesn't really deal terribly well with the positive duty that sits upon directors, but it does take them through the obligations of due diligence which exist in all state and territories but Victoria. In Victoria, the test of due diligence is a much lower test. You've got to demonstrate that a person has specific knowledge before they have a liability. It's objective everywhere else. I guess the thing that disappointed me in this is that we're seeing in this space of psychological hazards a whole lot of people trying to introduce software, introduce IT methods of capturing information around psychological hazards, but it ignores the fact that most psychological hazards occur and the person who's creating that hazard has no knowledge they're doing it. It's their DNA. It's the way they behave or lead, because most of them are leadership or design issues. And I guess what I
can't capture it with IT software.
Well, no, not unless everyone wants to engage, and the more you build complex IT solutions for capturing evidence, the more likely it is that the people who you most need to engage with it don't.
Right.
So what we're really trying to do is look at what is the basic information that tells you things are wrong, then building up a level of capability where we start to be able to capture observations from people at supervisor and manager level as to when there are hazards. But the first part of that is building the capability in supervisors and leaders to self-reflect and understand what are psychological hazards. So again, I've got to commend them for producing a document. It again refocuses people. But if I was a director out there, and I am a director who is out there, the thing that I want to know is the data I'm looking at accurate and representative of the risk? And I want to be inquisitive about that. I want to be satisfied that we're drawing from the broadest base, not just from the people who occasionally go and stick stuff in an IT system, which utterly misrepresents where the risk is. And I also want to know not only what the risk is, but what are the protective mechanisms that could be deployed, and what are the prevention plans that are in place. And again, in those last two elements, this paper is silent, like so many other papers are. So, look, great AICD for doing it. I think it's terrific. I really liked and enjoyed reading the paper, but can we just get back to the basics for a while, and can directors understand that their obligation is to intervene at this stage, to get the level of knowledge they need to be able to provide the governance they've got to do. Tom, I thought I'd throw you over to Nugent's case, because it's the our first case that we're going to talk about, and it's about covert recording, which we've talked about a lot over the last few workplace briefings.
Yeah, so in this one, it was an unfair dismissal claim. This worker had been secretly recording conversations with his colleagues. And
who does this, Tom?
yeah, it's a bit strange. He was doing it because he said he was paranoid about
I
adverse.
don't think you said paranoid.
Well, maybe not paranoid. Yeah. But it does seem a little bit. He wanted to have a proper record of all conversations that had taken
These
place.
were historical conversations. So
Yeah.
these went back years, and then he was sending them to people on emails.
Yeah, that part was particularly.
It was particularly weird. And then he was sharing it with senior management. He'd been directed not to do it on several occasions.
Yep.
And eventually his employment was terminated.
Yep.
So Queensland law is interesting. Queensland, like Victoria, you're allowed to record covertly a conversation you're a party to. Okay?
That's
No
correct.
other state or territory. But what you're not allowed to do is then to distribute it to a non-party.
And in this case, he was sometimes sending emails of these conversations to senior management and other third parties.
Yeah, bizarre stuff. But when he was terminated for doing it, and what the Commission properly said is, when people are told not to do something, particularly where it involves the covert recording of information, it goes to the very heart of trust and confidence that sits between you as employers. So it utterly breaches that connection.
Yeah.
Because if you told me you were covertly recording what I do, I'd be a bit distressed.
Yeah.
Not because I think I'm about to do anything wrong, but the relationship between us is not one where we sneak around putting recorders and cameras in walls and make crazy stuff like that. It is about us being people with trust with each other.
It's very open recording here.
Yeah, very open, by the way.
Yeah.
And thank to her again for such an open and good recording. But I guess the point that I want to make, we keep saying this, please make it clear there is not to be covert recording in the workplace. Be absolutely clear about it. Whatever state and territory, and make sure it's clear.
It's just incompatible with the trust and confidence.
It is totally incompatible with it.
Yeah.
Look, I think, where do we go next to, Tom? Because it's not showing on my screen.
Sorry, we're on Safe Work, Safe Work New South Wales v. Abdul El Orly. Am I pronouncing that right? I doubt it.
Can I say this is, I put this case in, Tom, and you'll go through the facts briefly, but I put this case in because I think, as you said when we spoke about it earlier, not only does this go against the trend, but this is right out there. This is a decision that a whole lot of people are going to utilise in small business, and they should understand it is an outlier. It's not right. The sentencing was wrong when we come down to it. But look, talk a little bit about the facts, because the facts are appalling.
Yeah, the facts are quite grotesque. This guy was working for his uncle, who was an arborist, and while working for him, he's gotten caught in an arborist rope and drawn into the wood chipper, causing he had to have both his legs amputated, a brain injury, friction burns,
Terrible.
just a whole host of.
So he ended
stuff.
up, because he pleaded guilty straight away, he ended up with $80,000 fine. Now, can I just say to you, in any court in Australia, other than this court on that day, the general deterrence provisions of safety, that is to say to people broader than the person who is involved, creating risk of serious injury to people will not be tolerated, is the predominant driver of tariff, okay? Tariff is what you're sentenced with. So there'll be an element of it, which is why you see 25% discounts for early plea, which is subjective. If you save the court time, if you admit show remorse, there'll be a discount. If you've got no prior convictions, like this guy didn't have, you've attended to the safety issues straight after, and it's caused you enormous personal impact because of it, well, yes, once again, there'll be a discount. But there won't be a discount of 70%, which is what's happened in this case.
For an injury that, like we were saying before, it's akin to a fatality.
Yeah, it is.
The damage.
It's so terrible, the damage that's been done. So I think anywhere you go in Australia, this is something that would have been a $200,000 to $300,000 fine.
Yep.
The fact that it's 80,000, I know there'll be those people who go, "Oh, you're a small business, don't worry too much."
Yep.
Can I just tell you that's not good law, and I will be surprised if this is not appealed. It's just one of those decisions where I totally get why the judge did it, and it's generous in a whole lot of things, but it goes against the general deterrence provisions that are meant to be part of safety law. Why don't we go on to our next case, which is a redundancy case, an interesting case, Tom. It's Sophie Barrackett and intelligent monitoring. Tell me a bit about the facts in this case.
So in this case, an employee, along with 7 other employees, had been made redundant the day before she was due to go on parental leave. She happened to be a top performer within her team. And the issue here was whether there was a genuine redundancy, but the interesting thing was, as soon as she left, they brought in someone else who was a decidedly low performer.
Yeah, in fact, it seemed to be the lowest performing team. And the test of redundancy is the job is no longer required to be done. Okay, so it might be that Tui gets axed as the director of this podcast, and that Tom and I take it over. Now that's her job is no longer required because we can absorb it. Okay, so that's a genuine redundancy. But if we replace Tui with some child off the street because it's cheap, then the job is still required to be done, and therefore it's not a genuine redundancy. So she won a case, hands down. It was a really easy one.
We wouldn't be doing that.
No, I wouldn't be doing that. It's my wife. All right, so why don't we talk about the toxic workplace? And Tom, you're going to flick it up, I'm sure, at some stage.
Yeah, sorry.
Yeah,
We're
William Dawes and Pringle's case. He's I tell you what,
rusty.
he's a bit rusty today.
My week off. Right?
Yeah, it was his week off, and I tagged him very late afternoon and got sick.
Yeah.
But maybe if we just go one more, Tom, then we don't have to worry, and I won't get so excited.
Okay.
So, toxic workplace. Mr. Dawes was a difficult soul, wasn't he?
Yeah, he was a problematic individual. He was in a supervisory role as a leading hand working for Pringles.
Yep.
And part of the people working under him comprised both male and female employees. And part of the allegations against him was that he was particularly rude to female members of staff, causing several of them to leave.
I was going to say these are significant bits of bad behaviour. They aren't me sort of rolling my eyes or being a bit indifferent.
No, it's targeted rudeness, swearing, things like that.
Yep.
But he tried to claim that it was a toxic workplace and that this behaviour was condoned.
Yeah, and he was responding to it. So first of all, he said, "Look, I'm not the cause; I'm the effect. You do this to me, I respond. I don't say it's good. Yep. Secondly, how can you blame me when it's part of the culture?" And there's a series of cases around swearing which go, if I say, "Oh, F this," and everyone does it, well, you can't sack me because it's condoned, it's part of culture. But if I say, "Go get effed," and everyone else is just using the word as adjective, then my behaviour is a step above that.
Yeah.
Particularly where it's directed or designed to hurt.
Mm.
So this is a case that goes to the very heart of that. And I want to do that because, once again, I've been out circling my clients in the meat industry recently who talk about this as being a constant issue, is that the language and style of people makes it complex. But the important thing to remember here is when behaviour goes outside of culture and becomes aggressive, threatening, rude, offensive, it elevates up the pole, doesn't it?
Yeah.
And that's really what was held here, wasn't it? That the nature of the behaviour itself, irrespective of the toxic culture, was so profoundly bad, it was serious misconduct, and therefore it was a valid reason, and the process was not objectionable, and so the termination was upheld.
It's a good one though, because I've worked in workplaces where that is accepted, and that is part of the culture, but it can be hard to delineate where the line is, but I guess in this case it was clearly going over and above.
It was. And so look, we'll come back to it because we re-agitate this case during the case study.
Yep.
And we do it with a more complex set of facts just to test the propositions we've been talking about. But there's a recent same job, same pay case, which is the BHP skilled engineering case. It was an application by the Mining and Energy Union in respect of at a particular site. BHP had skilled provide employees on the site. BHP paid at a very high rate.
Yep.
BHP tried to limit it to haul truck operators,
which they said was what the labour hire arrangement focused on. It was for haul truck workers, but in the end their role seems to have expanded to share a lot more similarities with the BHP employees.
And they paid significantly less. And BHP's argument was, one, well, let's limit it to this category, but secondly, same pay test can't be really paid people exceptionally high wage, which of course was at the very heart of the policy that drove same job, same pay, and the Commission just looked at them and went, no, that is actually what it's all about.
Yeah, it's exactly what it was designed to do. Yeah.
So no surprise there, but I think you should remember that when you do have these cases, where you do have labour hire and you do pay highly, you've got to understand that is the tariff. It's not what the award is, same job, same pay. It is the same job, the same pay.
Yeah.
It is as simple as that. Well, why don't we have a look at the main topic today? This comes out of a case with the ACCC, which eventually got all the way through to the High Court, and it was around the CFMEU saying to an employer, whatever you do, don't employ that subcontract, because if you do, we're going to take industrial action.
Yep.
So what is a boycott? The boycott is entering into an arrangement with another person to prevent the benefit to a third party. That's what it is. In industrial relations terms, when you look at major industrial action, there are secondary boycotts running riot. Okay, there's the union saying, if you do this, if you let those contractors come on the site while there is industrial action on, we'll do X, Y, and Z. So that's where you commonly see it. What this case dealt with, though, was, well, when you were saying there is an arrangement, this collusive relationship, arrangement, understanding, or agreement, what is the evidence that you've got to be able to demonstrate? And this case is a great example because there was a document that implied that threat that I just described, which is if you employ this subcontractor, we'll take industrial action. But there was no evidence that that agreement was taken up or acted upon.
Accepted.
Yeah, so there's no reciprocal action that shows that, yes, it's true that the subcontractor didn't come on site, but there's nothing to show that it was the threat that caused that to happen.
Yeah.
There was a really interesting side bits of information that occurred where the project manager or supervisor, whoever it was, tried to get the subcontractor on a union EA and hoped that would fix it. So there's a whole lot of facts which all suggest there was a collusive relationship. But as the High Court said, unless you can demonstrate evidence of explicit reciprocity, you cannot argue secondary boycotting because you can't agitate an arrangement unless you can prove that there was offer and acceptance effectively.
Which is a big problem in this industry because
Well,
that doesn't happen.
Yeah, and it just shows what a complete nonsense the provision is, because how do you control industrial relations, which has the most skilled litigant in the union involved in it, who knows exactly what the law and the rules are and expect to ever stop their misconduct?
Yeah.
So, look, it's the High Court, it's the right decision. It's a good decision, but what it does say, the Section 45D provisions, they're a nonsense because you can never ever succeed unless you have a unionist with half a brain who decides to document and the other side is even more stupid and agrees to sign it.
Would be a rookie error.
Yeah, rookie error. Rookie error. Why don't we, I thought that was, I put that case on because I just thought we're now right in the middle of enterprise agreement season. We're heading towards 30 June. We are seeing a federal election coming, which means the likelihood of industrial action is always increased during that period of time because they understand that the press are hot to hear it and that nobody wants to have that particular fight. So how do you actually deal with the union during these times? Who's doing that type of stuff? And the answer is the very same thing that you've always done, which is to use people taking videos of picket lines and behaviours. Make sure that you continue to test misconduct by the union and then document it, making contemporaneous notes. They're all the things you've got to do, okay? But if you don't record carefully what is happening, if you're not taking contemporaneous notes, you will never satisfy the High Court test. And therefore you'll be subjected to extortionate behaviour. Why don't we go on to the case study?
Right. So Yvette struggled with Dan's demeanour. He had been in the business for 30 years and spoke to her brusquely, at times saying things like, "You are too young to understand," while ignoring her complaints and requests for help. There were times when he was just plain rude. Sam felt the same. Like Yvette, he was new to the business, having been there for 2 years, and was young. He understood that the nature of the business was complex and that Dan seemed to know it all, but Dan would never stop to explain. He would give Sam a direction and expect him to follow it. When Sam failed, as he invariably did, Dan would roll his eyes and speak down to him. Sam felt isolated, unsupported, and hurt by the repetitive behaviour. Gordon had worked with Dan for much longer. He was highly skilled, and Dan most often turned to him for guidance. But Gordon felt burdened by the workload. Although he recognised it as a sign of trust, he was tired of Dan's constant bellyaching about others and his refusal to train him. Gordon was ready to leave and was also wary of the ongoing conflict between Dan and the others. Yvette had returned from parental leave after 12 months. After just 4 weeks back at work, she'd had enough. Her child had suffered from croup. Don't know what that is, don't want to know. She had hardly slept Her husband was on FIFO shifts and she was falling apart. Everyone could tell. Her role was as an estimator, working directly with Dan's team. Dan was disorganised, and too often the documents Yvette needed would come through the system late on Friday afternoon, with the deadline for response early on Monday or Tuesday. Her job was Monday to Friday, but she often worked most weekends. She requested flexible work arrangements 3 days a week, one of them from home and no work on Fridays, while asserting her right to disconnect over the weekend. Dan and his boss discussed the flexible work request. Dan's boss, Carl, spoke with Yvette and explained that the role was full-time and Fridays were crucial for the team because all of the trades came together on that day to undertake reviews, assessments, and document management. Yvette explained that it was impossible to work in the current environment. She felt that Dan was hostile, lazy, disorganised, and that working with him was detrimental to her well-being. Carl said he understood, but emphasised that they really needed Yvette, as she was brilliant at her job and irreplaceable.
All right, so we sort of come to the questions from all that. Interesting case study. First one, was it a proper refusal of flexible work arrangement? So the question is, she's put in a written request for flexible work. They've done the next thing, which is the consultation process, which is their obligation to go back and consult. And they've said during that consultation process, look, it's full-time. The nature of the role involves a number of other people being present at a particular time to provide final instructions, so the Friday is not there. And more importantly, there is no particular attribute that you relate the flexible work to. It's just that you don't like working with Dan.
Yep.
Now, that's a nice way of what they said, and what they also said is you're invaluable and we need you. So the first issue is there was a request for flexible work. Was it in process? Had they dealt with it appropriately? To the stage it has got to, yes, they did, because they haven't reached the stage where they write back refusing. But the stage you're at is consultation. The next stage would be to write back and refuse. So at the moment, there is not been a completion of the process. So in process terms, what they've done is fine. Okay?
Right.
The second issue really is does she have an entitlement for flexible work based on the elements of which she would seek to do flexible work?
Yep.
She's not saying that. She's saying she can't work with Dan.
Yeah.
Now she does. She has caring responsibilities. She has a whole lot of things she can build a flexible work around. But they're saying, and they're quite properly saying, this is a full-time job. It has these limitations that sit upon it. I think they're okay. Okay, they're okay with the refusal, not okay with their behaviour. Okay. So let's go to the second question.
Would Yvette have a discrimination claim? If yes or no, what actions should the business have taken given their observations of her? Think Burke v Suncorp.
Yeah, so Burke and Suncorp, it's a 2015 case that said that, in this is a general protections claim, that the obligations of law now arose when a reasonable person would observe someone through their obligations to monitor health under safety law, that they were not fit for their work, or that they posed a risk of safety for their work. So here, everybody knew exactly what was going on with Yvette. They knew she was falling apart.
Yep.
So her protected attributes were obviously she had caring responsibilities and it was impacting and damaging her. Okay.
Yep.
The second one is it's unquestionable she had some sort of mental health issues that were occurring. So there's two attributes which required reasonable adjustments.
Yep.
The reasonable adjustments aren't hard, are they? One of them is stopping Dan.
Yeah.
You know, the big issue here is they've not managed Dan.
Yeah. Whose behaviour is quite egregious.
Yeah, and causative for what's occurred here.
Yeah.
So in some ways here, they don't even have to make reasonable adjustments. They just have to stop the bad behaviour.
Yeah.
If they stop the bad behaviour, I think it would work. But even if they said, okay, we need to do more to actually meet because she's now damaged, it may be providing, talking to her about the time she actually needs and making sure that work only goes through at particular times. It may be providing her with assistance along the line until the disability that she now has ceases to exist. So there are reasonable adjustments that need to be made, and there is undoubtedly the risk of discrimination. It's just not the best claim she could bring, is it?
Yeah, so what you're saying is because she's putting this request because she wants to escape Dan, not because she has any of these other, valid reasons.
No, but for discrimination law, she does have protected attributes. She is damaged, so she does have a harm. She does have caring responsibilities. She's saying that the way they are treating her through Dan as their agent is causing her harm and treating her adversely because of that. In Victoria, where the law is very clear, it just has to be adverse treatment. She's up and running in other territories where you've got to show detriment and a comparative study, she's still going all right for discrimination. The problem is, it's a tough claim, okay? And it's a tough claim because she's the person who has to prove the case. Whereas in a general protections claim, once she raises it, demonstrates it, the risk moves over to the employer, and the employer has to prove it.
Yep.
So this is a perfect general protections claim for it.
Okay.
Even though she's currently employed, she still has a capacity with it. So were there any other safety law breaches in this, Tom?
Well, I think in this one there's a clear safety risk, psychological hazard to her, which is evident to everyone. She's falling apart.
So let's do it just to start off in one at a time. So there is a primary duty breaches, and it's not a safe work environment. There is a failure to monitor health correctly and to intervene.
Yep.
So we've got primary duty breaches, but the fact is they do know.
Is that in respect of Dan?
Well, that's in
Failure
respect
to stop
Dan.
Dan.
Yeah, well, Dan's the agent of the organisation, so at the moment they're both the same. If that makes sense.
Right. Okay. Yeah.
Dan hasn't been stopped, so Dan doesn't go quite as badly as the business. The business is on notice of how bad Dan is, and it does nothing about it. So it's moving towards reckless endangerment. And would they be prosecuted? The chances in this scenario of them being prosecuted in Victoria at the moment, very high. Pretty high in Queensland, and reasonably high in South Australia and New South Wales. So, yeah, I think there's obvious safety breaches. What happens if Carl commissioned an investigation? We've got Andrew's teleprompt here because I'm a bit old and forget things, but Tom's actually playing with it at the moment. If Carl commissioned an investigation or review and found all the above was true, would they be able to lawfully dismiss?
Yeah, I think so. I think once they've investigated what's going on and discovered Dan's wrongdoing and the effect that it's having on employees such as Yvette, they would have strong grounds for it.
Look, this is less than the other case, Dawes case that we looked at before, isn't it? Okay, remember we looked at Dawes case around what you could do in a toxic environment and all that type of stuff. And remember you and I chatted earlier and you said to me, is it enough? Is it enough for a valid reason? And I agree with you. I think it's enough, but it's borderline. But it does show what the responsibility on the business is to intervene because all the other causes of action are alive. So I think once you've got a valid reason, then you're off to determine what is the process. We don't know the process. But yeah, I think an investigation would demonstrate there's enough there to turn that.
Was it that right to claim she could disconnect? Her contract was paid above award rates and stated she must work such extra reasonable hours to undertake the work.
So can we just start there? Now the right to disconnect is a funny text, isn't it? Because what it is, it's the same sort of thing. You don't have a right to disconnect. What you have is if you resist being called out of hours or asked to work on out of hours, then if someone treats you adversely as a result of your refusal, you have a claim. So it's not you have a right to disconnect. But the law says if there is a good business basis for you having to stay connected and the process around it is reasonable and fair,
and you have to justify your refusal,
then you have to justify your refusal. Right? The answer is here she has an argument to say, look, I'm being asked to do things that are unreasonable. Yeah. And that's because of Dan's incompetence. And I should have more control over my life. But it's untested because she hasn't refused yet, so the right doesn't, the adverse action argument doesn't kick in.
So is it unreasonable because Dan is providing the work so late on the week on Friday?
Yes, right, it is. So I think she has a right to say no, and she would be successful if she did say no because of the misconduct of Dan. And finally, would Yvette have a good workers' compensation claim? Every single hour of the day and night she would get out of the line twice on Sundays. Most of this goes under the subjective test, so in other words, she experienced behaviour that was bad, she wins. That's it. So yes, she'd have an excellent workers' comp claim. So fun case study, Tom, and well done for just jumping in at the last minute.
That's sure it is.
We'll see you the same time next week. See you later. Bye-bye.